Welcome to another edition of Question and Answer with a Criminal Defense Attorney. I'm Mark Solomon, a defense attorney in Denver, Colorado. Today's question is about mandatory protection orders. Before we get to the question, don't forget to like the video by clicking the like button, hit subscribe with a little bell next to it to be notified of future videos as they come out. I'm doing my best to get these out daily. Now, let's get to the question. What is a mandatory protection order? Let's take a look at a protection order and start from there. So you can see the top lists information about the case. The next section down lists information about the protected party, as in names and date of birth, basic description of victims and witnesses. And if we scroll down a little bit, we can see the court has the ability to check any number of these boxes off to the side, paragraphs 1 through 8. And it can require a lot of things. It can require somebody obviously not break the law as to that victim or witness, but it can also require them to move out of the house in the case of a domestic violence case, and to refrain from contacting that person in any way. We call that a no contact order. The judge can also prohibit a person from possessing a firearm in any way, and that's almost always done in felony and domestic violence cases by law. And lastly, or second to last, this paragraph number 7, it can also prohibit a person from possessing or consuming alcohol. These are listed in every single time a police officer does an ID check on somebody. If one of these protection orders is enacted, this no alcohol provision will also come up. And if the person smells like alcohol, will probably be arrested for a violation of protection order. This last paragraph, number 8, talks about anything else the judge wants. However, most of the time, these protection orders, it's either written or stamped on them that the protection order is a condition of bond, which means that if you violate this protection order, you're also violating bond, which is significant because a violation of bail bond conditions has a mandatory minimum 6 months jail sentence. So be careful of that. So, strictly speaking, the answer to this question we're looking at is it's required in any criminal case under Title 18. It lists protected people and may forbid contact with them. Those are called no contact orders. It also can prohibit the possession or consumption of alcohol and firearms. So, that is the question and answer for today. If you would like your own question answered on a future video, you can post it in the comments below, email it to me, or put it on Twitter. And as always, you have a right to remain silent. If a police officer asks you what you've done, where you've been, what you have, or what you know, you have a right to say, I don't want to talk to you. And if they persist, you also have the right to say, I want an attorney.